I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my vindicated co-host, Brett.
That's such a good word. That was a great word.
Good word.
You know.
And it's actually appropriate.
So perfectly. As I sit here, drinking my Pappy Van Winkle, celebrating a rare instance of justice. I've become a little cynical, I gotta say. You know, these Supreme Courts have been letting me down lately. First the Indiana Supreme Court, then the Arkansas Supreme Court. But Maryland came through. And I had my doubts. I doubted. I admit. I repent of my unfaith.
I have to jump in there. I don't know that you had unfaith. The reason I say vindicated, and it is not to, look, this is a sad day. This is a sad day because we are only here today. Obviously, guys, we're talking about the Maryland Supreme Court decision on the Adnan Syed case where the conviction has been reinstated. No one is joyous about what's happening. I am not happy that we have a murderer. I'm happy that justice is going to be done. I'm not happy that this had to go all the way up to the Maryland Supreme Court in order for victims' rights to be vindicated. I'm not happy that the Supreme Court had to write a 90-page opinion in order to explain a very straightforward case to a world that has lost its mind. This should not be a 90-page opinion. The reason it had to be a 90-page opinion, we'll talk about that opinion because I was very impressed by it, is because of what the true crime world has made this case out to be. And I will point to a paragraph within this 90-page majority opinion. The whole thing is 187 pages with the dissent, but the majority opinion is 90 pages. I am not happy that we have to be in a world where so much ink, time, taxpayer money, resources have to be spent on something that shouldn't have warranted all of these resources, from armchair detectives to Maryland Supreme Court justices. And I am not happy that Hae Min Lee is dragged up repeatedly with her family and is victimized over and over again, decades after her horrific murder. So please don't take that word vindicated to say that this is some joyous occasion where we get to be right. I don't want to be right in these types of cases. We are vindicated because for once it feels like the Reddit crowd doesn't win out in the face of very straightforward legal justice. And we will explain to you what we mean by that because we have read the opinion and you should too. It is a good opinion. Read both of them. Read the majority, read the dissenting. We're going to spend most of the time on the majority opinion because if you've been listening long enough, you know that the majority opinion has the majority of votes, and that is the governing opinion. Dissenting opinions have no force of law. They explain, a contrary position, but that position didn't get enough votes to be the ruling opinion. So with all of that said, I just want to explain myself because every word that comes out of our mouth that even begins to touch upon Adnan Syed is torn to pieces, and I want to explain that descriptor because this vindication is in no way joy. This is still a very sad occasion.
Well, as the Bible says, the righteous rejoice when justice is done. So I'm going to rejoice that justice is done. But Alice is right. Really, people should be angry, and the Maryland Supreme Court opinion should make you angry, not because it's undoing this sham that occurred in the trial court, but because this fraud on the court happened in the first place. And if you read the Maryland Supreme Court's opinion, if you go back and read the Court of Appeals opinion, particularly the footnotes, and then you read the Maryland Supreme Court opinion, and it is very well written, and you just see they got it. I mean, they understood what was going on here. They saw through the farce. And they made it very clear that they saw through the farce. And they saw not only was this a farce, but it was just an incredibly callous attack on a victim. I mean, I don't know how else to describe it. When you read the facts and you read the procedure and how this all went down and just the absolute lack of empathy for Hae Min Lee's family and just the inability to even give them the barest accommodation. Literally 1 week. 1 week is all they asked for. If the court, Adnan Syed and his representatives, if they had had just an inkling of humanity for these victims, this would be over. If they had waited a week, this would be over and done, and we wouldn't be talking about it now. But because they didn't, this is the result. This is the whirlwind that they reaped. They're the ones who sowed this. They're the ones who planted the seeds for this to happen. And, there is something, just the karma of it all is remarkable. And it is a testament, once again, to how important it is when you're in the justice system to do things right. And we talk about this from the prosecution perspective all the time, how important it is for prosecutors to follow the rules, to do things right, to act with integrity, how important that is. And I think most people appreciate that. But for some reason, when it was the defense in this case and Adnan Syed's representatives in this case, it didn't matter that they cut corners, and it didn't matter that they ignored the law, because the end justified the means. And we talked about this in previous episodes. But what the Maryland Supreme Court essentially said here is, no, you are not allowed to trample on the rights of victims just because you think you're in the right. And they even say that essentially in their conclusion. So I hope you guys will read it. We're going to talk about it, what it says and what it means, but it is worth a read. It is a long opinion. As Alice said, I think all total, it's like 180 pages, and there's a few dissents. So the majority is about 90-something pages, and the dissents altogether, I think there were 3 dissenting justices. This ended up being a 4-3 decision. I think I'm not making that up. So a close decision, but a good one nonetheless, and one that, as we are going to see, is going to have massive effects. I think not only for this case, but just how victims are treated in Maryland. I mean, this was a huge victory for victims' rights. I mean, put aside this case, this really matters for victims' rights.
And this is really interesting because typically this is such an interesting case because essentially everything's been flip-flopped, right? We have typically defense counsel who want these sorts of open rights and whatnot. And you'll see, again, I really challenge all of you to go read this opinion. Why? Because it is a beautiful treatise on the history of victims' rights. And of course, it's specific to Maryland, but it also branches out into like what victims' rights means, why there are victims' rights laws, and what the spirit of the law is, diving into legislative discussions at the time of passing these acts. And they're relatively recent acts that you'll see, because there was a time when victims didn't have a voice in court. And it fleshes out the reasoning and the principle underlying why victims should have a say in court. And it goes all the way back to how we used to prosecute cases. Victims had to be the ones who prosecuted cases out of your own pocket. And maybe if you won, there might be damages and it would cover your costs. And then we shifted to a state prosecution system where the state goes after and vindicates the victim's rights. But by doing so, they've taken on kind of the onus of what the victim used to have to carry. And we've decided as a society, that's how we want to prosecute cases. And, it really is helpful to see the genesis of victims' rights and why we arrive at where we are today. And also, it's very forward-looking as to what happens from here on out. Because if you read this opinion, a lot of people are like, oh my goodness, this changes victims' rights completely. If you read the history of how we get to where we are today from the Maryland Supreme Court case, you see that no, as Brett just noted, this was a really egregious case. And it falls square, like they don't have to like expand the meaning of victims' rights or constitutional protections for the defendant in order to rule on this case. They essentially say this in like 10 different footnotes. This is an easy case. And we'll go through the facts of why this is an easy case. But note that when you hear people say, oh, well, they're changing victims' rights completely, read this really helpful history treatise of what victims' rights means and why this case is an easy decision. And I think we've said that before. We didn't know if the Maryland Supreme Court would be feeling the pressure of the Adnan is innocent campaign and come out with a more wishy-washy opinion. But we said it before. The law is clear here. And it was just a matter of the Supreme Court they are the supreme one in the land. They can come out contrary. And I'm really happy to see that they hew very closely to the law. Nothing, in their opinion, comes from Reddit, comes from X or Twitter. It is squarely rooted in case law legislative explanations. We can talk about whether you want to take into account legislative intent, but looking at the actual statutory language that we are applying in this case. But we've given all this primer. What actually happened in this case, Brett?
So you have the Supreme Court decision, and it's always interesting when you have an appellate court decision and a close one with a dissent. Whenever a Supreme Court can sort of decide whether it's going to take a case. Supreme Courts in most states, and certainly the United States Supreme Court, have a lot of ability to choose their own cases. If they don't want to take a case, they don't have to, except in some circumstances. So usually when you see a Supreme Court take a case, if you liked the lower court's opinion, you're kind of like, oh, I don't know, what are they going to do? Did they take it just to uphold it, or is there a problem here? But one thing I think people forgot, and even I didn't think anything of it just because I didn't think it really had any chance to succeed, was actually there were cross appeals here. So you had Young Lee, who appealed a portion of the appellate decision, and obviously you had Adnan Syed, who appealed the rest of it. Now, Young Lee, the appellate court decision basically just said, look, you had a right to be present. A last-minute Zoom did not satisfy that right. So therefore, we need to do this over again where you can be present, but you don't have a right to really do anything. You don't have a right to challenge the evidence. You don't have a right to participate. You don't have a right to speak. You have very limited rights, but you do have a right to be there. And he challenged that and said, no, look, being there includes other rights as well. And I think I have a right to be heard on the merits. And so he appealed that. And then Adnan Syed appealed just the fact that he could appeal, said it was moot, said he didn't have standing. So all sorts of things, said that the victims' rights laws in Maryland didn't mean you had to be there, that the Zoom appearance was enough. I mean, that was essentially what he was saying. Supreme Court takes the case. Well, it turns out, at least in the end, whether they intended this or not, by taking the case, they actually gave a more favorable opinion to Young Lee than the appeals court, which I didn't think was possible. The appeals court, as I said, only said that Lee had the right to be present. But according to the Supreme Court, the victim, quote, has the right to be heard at a hearing on a motion to vacate, including on the merits of the motion through counsel if counsel has been retained. And we're going to talk about this more as we go through this, but it's hard to overstate how important this is, because this changes the character of this entire proceeding. Before, it was a fait accompli. The state saying vacate it, the defendant's obviously saying vacate it, there's no opposition, there's no adversarial process. It's just going to happen because nobody's opposing it. Now, when this goes back, it won't just be a fait accompli. Young Lee is going to have an opportunity to challenge, to some extent, the merits of this vacater and say, on the merits, this shouldn't happen, and you, judge, have the discretion to not vacate this conviction, and that's what you should do.
And really interesting thing about two things about this. Number one, you've got to wonder the facts. We always say bad facts make bad law, that sort of thing. I don't think this is bad law, but I do think it's really interesting. The facts of this case is that Young Lee had counsel present at the vacature hearing where he was appearing by Zoom. And the judge specifically said, and this is in the opinion, the judge does not allow Young Lee's attorney to speak at that hearing. And it's such an extreme position because remember, it's at the district court level, right? There's no time constraints. There's no jury there. You're not wasting anybody's time. So it is actually pretty extreme when you don't let someone speak, when there are no reasons, no rules against letting someone speak. And so I do wonder how much harm that fact did in the court ruling very strongly in Young Lee and the Lee family's ability to speak at this hearing because his attorney, who he did have, was so completely silenced. And the second thing to keep in mind here is that when we have unopposed hearings, and we do have these, as prosecutors, sometimes it'll be something pretty simple, like they violated they're out on bond or something, and everyone comes back is like, yep, we agree, bond should be revoked. You don't have to present evidence. You don't do anything. It really is kind of like, we agree, the judge rules. Here, the Supreme Court was very clear that in this instance, the victim may be able to bring up points and keep it an adversarial system. So the whole point of letting the victim representative speak in this instance is to keep an adversarial system when you have the two parties who are on different sides of the V agreeing in one thing. And that is also a very, very important thing here, because we do know that no evidence was presented at the first hearing. So there was nothing to respond to. So much, there's several footnotes in the Maryland Supreme Court's opinion where it said this hearing was really for show. So even though Young Lee may have had an attorney present, may have appeared by Zoom, the fact that nothing was presented, he didn't know what the arguments were for, so he couldn't respond to them. That made it something happening in the dark. And that is not what we want in our justice system. We don't want things off the record. We don't want things behind these smoke and screens. And so in a way, by having the victim's representative be available to speak, it forces all of the things that happen in the dark into the light. So these are themes that we've talked about in lots of different cases. Adversarial process preserves justice, right? And secondary, that nothing should be happening in the dark through the judicial system, because it is our judicial system. It is not just the two people on the V. It's not their own private little system. We don't have private arbitrations in our judicial system. We have it for the entire public.
And one thing that's just wild about this, and this speaks to what a farce this was, and how foolish it was, the way they ran the whole thing. It was, as Alice said, costless to let Young Lee make his arguments, let his lawyer speak. Costly. Even if you don't wait 7 days. Even if you just say, look, we're not going to wait 7 days. Adnan Syed's in prison. He's been in prison for 20 years. 1 more week is an injustice, so we can't wait 7 days. But we're going to give you all the time you want. Your lawyer can say anything he wants to say. Take your time. In anything that we do, there are often circumstances where the decision is already made. For instance, there are sentencings where the sentence is a required sentence. Like you might have a sentencing, and I've seen these, where it's a mandatory life. The judge is going to give life. Now, he could walk in, sit down, say, this is mandatory life sentence. You're sentenced to life. Everybody have a good day and leave. But that's generally not what happens. Oftentimes, the victims will have an opportunity to speak. Family members will have an opportunity to speak. Family members of the accused can speak as well, even though it's not going to mean anything. Think back to the Rust case and just sort of like putting stuff on the record and allowing the record to be developed. Remember how at the end of the hearing to determine whether or not the indictment against Alec Baldwin should be dismissed, the judge asked the two attorneys, do you have anything you want to say in argument? And neither one did. And then the judge read her opinion, which she had already written. If they could have argued for all day long, and it wouldn't have made any difference because she had already made her decision, and that often happens. But nevertheless, you give everyone the opportunity to speak. It's just part of the process. And the fact that that didn't happen here is so bizarre. It's just unusual. It's not the way it's supposed to happen, and it's not the way it does happen. And what's interesting about it is it would have been something that didn't really matter. He's going to say his piece. We're going to do what we're going to do anyway, and it'll be over. But now, because the Supreme Court is saying, well, now that we've had the opportunity to look at the law, actually, he can do more than say his piece. He gets to make an argument as well. So after the court sort of gives, and I love this, courts out there, when you're writing opinions, the Maryland Supreme Court lays out exactly what it's going to rule in the first paragraph, and then goes through its opinion, which is great. So after they say, hey, this is what we're going to rule, then they sort of started going through this. Like Alice said, they talk about the history of victims' rights. They go all the way back to the Code of Hammurabi, and even before that. And, how victims had the right to chase down people who who wronged them and exercise their own justice, and how our system developed and how the state took control and that sort of thing.
Brett, it was like the legal equivalent of bringing your receipts. I mean, this is so heavily cited. There's a reason it took so long for these opinions, because there's many lengthy opinions to come out. But just about every sentence is cited. Cited, you can go to the citation, where it's coming from. I mean, this is truly chocked full of legal analysis and legal citation, and this is the way it should be. If you're reading about this case online, stop. Just go read this opinion, all of it. Again, there are multiple sides of competing opinions on this, but I would say stop listening to us for all I care and read it, because not every opinion is this thorough. So, as the kids say, the Maryland Supreme Court showed up with receipts.
So the court goes through this history. It then goes to the history of Adnan's case, does the thing that I always enjoy where it says all the reasons he's guilty, and then moves on to the vacatur hearing itself and how it was rushed and how the court refused to make any concessions for young Lee to exercise his rights under state law so that he could attend the hearing. In fact, he only asked for a week. He asked for 1 week to come to the hearing, and even that was something that the court would not allow him to have.
And so first, the court found that Lee's appeal was not moot, because if you remember, pending his appeal before the response was due for this appeal, the state could have set a new trial or nolo prost. So just, said they're not going to prosecute, and they decided to not prosecute. And so the first question was, is young Lee's appeal moot? The court said absolutely not. The state's attorney could not enter a nol pros without first vacating the conviction. So if the vacation was invalid, so too was the nol pros. Think about like a domino effect, right? If you go back in time and the first domino was wrong, then the second domino couldn't have fallen. That's essentially what they're explaining here. Then the court explained the actual rights Lee had. And it wasn't just that he had to be there at the hearing, but that he also had a right to be heard. This was a right that was to have meaningful participation, meaning that he had a right to be heard on the merits of the vacatur. And note that in order to have a meaningful say at the hearing, you have to actually know what evidence you're responding to. And that was part of the problem here, was nothing was presented. Now, it's very possible that all of this was discussed. There was a hearing on a Friday before this Monday vacatur hearing, but it was in camera, meaning not an open court. So young Lee wasn't told about it. No one was there except for the defense attorney, the state's attorney, and the judge, and it wasn't on the record. And so it's very possible that they talked about a lot of evidence, and it appears they did, but none of that evidence was presented in court on the record for Mr. Lee to respond to. And the Supreme Court had a problem with this because, again, you can't meaningfully respond to something you don't know exists. Now, vacatur is not required just because the prosecution files a motion for it. Remember in past legal briefs episodes, we've told you that the prosecution holds a lot of power. That is without a doubt. As the prosecutor, you're the gatekeeper. You decide whether to even bring a case forward to the grand jury. Of course, the grand jury has to grant a true bill to then move forward with charging. But the prosecutor, before he even gets to that phase, has the decision whether to even bring it at all or to decide not to go forward with the case and not to even try to seek charges. But as you move further into a case, especially once it gets to conviction, the power of the prosecution over the case becomes less and less, as it should, because now you're involving other parties, the judge, the jury. And so here, the court's being very clear. The prosecution doesn't hold all the power here. Just because they're saying, we want to vacate, doesn't mean it must be granted. It's discretionary. And the victim should be able to argue that the court not exercise their discretion to grant the motion to vacate. The Supreme Court then noted that in a proceeding where the defense and the prosecution both agree, which is what happened here in this case, then having the victim actually address the evidence preserves the adversarial process, because then someone can speak up for the other side. We've noted this before, like at the Supreme Court level, when one side will decide, like especially a state or maybe the government, they're like, we're not going to push this issue anymore. But it is still a very important legal issue. What does the Supreme Court do? Do they just say, well, everybody agrees, we're just going to grant what all parties agree to? No, they typically appoint an attorney to argue whatever side the state has decided not to take up to preserve that adversarial process. And so the court is saying the victim plays a very important role, especially like in this case, the state and the defense are on the same side.
And, when I read this part, it was like they were listening to our podcast, Alice, because this was the thing that drove me crazy when we talked about this when it happened 2 years ago. Just the absolute absence of any kind of adversarial process to test the evidence. No, it was just asserted that Well, there's DNA. Well, there's Brady material. It's just asserted. Nobody tested it. There was no testimony. There was no cross-examination. There was no adversarial process whatsoever. And the Supreme Court is identifying that as a problem and saying, look, this is our process. We don't just put people in prison, and we don't just let people out of prison without challenging the evidence and allowing the victim to speak. Preserves that adversarial process.
I think in this case, the Supreme Court does something, uses a rhetorical device that I think is very convincing. So if you read this opinion, obviously, even the dissents, like, they spilled so much ink to try and say something so simple, like blah, blah, blah. It's way too long of an opinion. And I've explained at the beginning why I think the opinion had to be much longer than necessary. And it was necessary in this case. If you read this opinion, so around page 13 or 14, the majority opinion spends a total of 1 paragraph on the concise evidence as to why Adnan Syed was convicted. They don't say one way or the other, like, we believe in the strength of the evidence. This is not a 10-part, 11-part podcast episode. It is 1 paragraph between the pages of 13 and 14 in like 5 sentences. They say, because of this, and this, he was convicted. And then they spend approximately, 10 to 12 pages on the evidence that was supposed to be new evidence that's going to rile everything up. And why I think this was a really good rhetorical device is, like, this is not a complicated case. Here's the convicting evidence. It's so simple, I can tell it to you. I can tick it off in 1 page. Now, I have to spend 10 or more pages to explain all this other stuff that may or may not, DNA that may or may not be there. You can always bring these things up, but no one argued these things. Look how simple it is on paper. And they don't say it specifically, but they do it in the amount of ink they spend on each one. 1 is very short and concise because guess what? When something's simple, you don't have to spend much time explaining it. The reason they have to spend 10 or more pages explaining the supposed evidence that calls into question the conviction, but never does. They're pointing out the very fact that this wasn't tested. And if you read this opinion, you can see why there's a lot of questions to be asked. This is not a slam dunk case that this evidence would somehow overturn all of the very simple, 5, 4, 3, 2, 1 points of evidence that lead to conviction. And so they're pointing out in the way they describe the facts or the alleged facts that would change the conviction to show that we didn't have an adversarial process. We have lots of questions. We're not in the position to ask those questions, but someone should have. One of the attorneys, nope, they weren't going to do it because they were on the same side. The judge, nope, the judge didn't do it. And you know what? This opinion does something that no judge ever wants to be in the position of. The judge who made this decision, a lot of you are asking questions in the chat. Why did the judge not let, young Lee's attorney speak? This judge was called out by name in the opinion. I never want my name to appear in any opinion ever in life. This rarely happens because they're cohorts. They're all judges, right? So it's a big deal to call out a judge by name. They do it pretty much in footnotes. And they do that, I think, to save face. But the Supreme Court is very clear that this judge acted in a way that cannot be trusted in the future, which is why they reassigned the case on remand to a new judge. That is the epitome of basically one of the biggest slaps on the wrist a Supreme Court can do for a lower court judge. And that's done in this case. That should tell you how much disdain they look at what happened at the lower court because it trampled on the victim's rights.
And as Alice said, part of the problem with this opinion was even the evidence on which it was based. And by this opinion, I mean the vacatur opinion. Even the evidence on which it was based was secret. It was secret to the Supreme Court. Even the Supreme Court did not have the record. And they talk about how it was not only error to not allow Lee to speak, it was error to conduct the important part of the hearing, the evidentiary portion in this cloak and dagger in-camera hearing where the evidence was completely opaque to anyone. It did not become part of the record. And as the court said in a footnote, and if there's anything you learn from us, it's to read the footnotes. Because as Alice said, the appeals court was pretty vicious in their footnotes. The farther away you get, that sort of higher up you get, the more collegial everybody's trying to be. They're trying not to be mean or anything, particularly in the body of the opinion. But in the footnotes, sometimes you can see what they're trying to say. And I'm going to read you this footnote. And it's written in this beautiful sort of court language where they're being very gentle, but making a very pointed argument. So here's what they say. The record could lead a reasonable observer to infer that the circuit court decided to grant the vacatur motion based on the in-camera submission it received in chambers, and that the hearing in open court a few days later was a formality. As Justice Watts noted at oral argument, there seemed to be a predetermined understanding at the vacatur hearing of what the Brady violation would constitute, as well as a predetermined knowledge between the parties that Mr. Syed would be placed on electronic monitoring, and there would be a press conference outside the courthouse immediately after the hearing. This raises the concern that the off-the-record in-camera hearing, of which Mr. Lee had no notice, and in which neither he nor his counsel participated in any way, was the hearing where the court effectively ruled on the vacatur motion, and that the result of the hearing that occurred in open court was a foregone conclusion. Essentially what the court is saying is, the hearing was a farce. It was a fait accompli. Everybody, except for the victim, was in on the joke. The press was out there waiting to capture pictures of a victorious Adnan Syed and all of his supporters as they came out of the courthouse with the vacatur having been granted. This is not how the law is supposed to work in this country. And I don't care if it's, like I said, if it's a prosecution, a vacatur, whatever it is, we are supposed to have actual process in our country where we actually decide questions based on the facts in the law, and we struggle with them and we come to some sort of conclusion. This was just a farce. It was a farce from beginning to end, and the Supreme Court recognized that, and I think it had a lot of influence on their decision. I mean, they're basically saying, look, y'all want to argue about whether or not he got notice to the farce hearing. We're saying that the real hearing, he didn't get any notice to. Nobody did, because it was held in secret, where everybody who had already agreed, including the judge, decided on exactly how this was going to go down, including where the cameras were going to be for the press conference. I mean, that's essentially what the Supreme Court is saying.
That was footnote 36. It was spot on, and the fact that it could have easily been in the body. I worked for a judge who didn't believe in footnotes. They thought anything, it's kind of like if you can't say anything nice, don't say anything at all. But it was the opposite. It was like, if it's going to be in the footnote, bring it up to the body. Like, let's let everyone read it. And it's true. There are many, many footnotes in this opinion. They are all worth reading because I think there's no reading between the lines. They're very direct, and I think they have to be direct. And in multiple of these, they even go into each of the arguments because it can kind of muck up the main opinion and addresses every single argument by both parties and notes where the judges or the parties get it wrong. And they are very concise in how they call out the misreading of the law or twisting of the law in a way that is inappropriate. So now, the court did not go so far as to say that a victim can present their own evidence or call their own witnesses. This is an important distinction because I have seen some people say, well, this totally changes. Now we have essentially a third party present in really a two-party sort of hearing. They're saying that they can address the merits of the vacatur, but you don't get to like turn this into your own sort of hearing. So the long and short of it is where this case is now is it's remanded back to the position it was immediately after the state's attorney filed the vacatur motion. So go back in time. Like if you're playing Monopoly, you go back to the time where the state has filed the vacatur motion, but nothing else has happened. And as we noted before, a new judge will be appointed, which is a clear indication that the Supreme Court does not trust the ability of the old judge to be impartial. Now, in the footnote, they say it nicer. The Supreme Court says something like, we wouldn't want this to seem like it's just going through the motions because it's already happened before. We want to make sure that everything is out in the open. But essentially what they're saying is, you did it all wrong before. You did it all wrong in such a way that was, we can't trust you again. And there's no way that we're going to give this back to you. That, again, doesn't happen very often, the remanding to a different judge. Now, Lee and his counsel at this next hearing will be permitted to argue against the merits of the vacatur. And of course, that evidence of why there should be a motion to vacate will be presented in court. So we'll actually know what it is. And it's probably going to be a lot of what the majority has laid out in their opinion. And they'll get to stress test it and say, like, doesn't matter. Does it go to the key evidence that led to Adnan's conviction? Because you can DNA test anything all day long. You can come up with all these other sorts of arguments all day long, but they can be around the edges and not actually go to the heart of why he was convicted. Now, one thing that a lot of people have asked is, okay, if the conviction is reinstated, does Adnan Syed go back to prison? The answer is no, because what was appealed here was not the release conditions. And the Supreme Court says it in a footnote. They're like, we're not reaching that because that's not what was appealed here. This is just about the vacatur motion. So he's still out on bond, and he will be until this next hearing, and we'll see what happens. So don't worry, no one's getting dragged back to jail, all of those things. I think there's a world where they could have reached it if they really wanted to, but they didn't. Right? They are just reaching the legal arguments right before them. So where we are now, we have a convicted murderer who's currently out on bond because that portion has not been ruled upon by the court, and it won't be. And we are going to have an actual hearing about whether his conviction should be vacated. And a lot of you say, well, won't it be? Because it already was before. No, we'll have a different judge. We'll also have a different state prosecuting attorney. You guys remember kind of the political atmosphere around why this was led to be? We don't need to rehash all of it, but there were political motivations behind the previous elected officials' decision to file this vacatur motion and the null pros of the case. That person is no longer there. So I don't know what the outcome will be, but it will not be a foregone conclusion that the conviction will be vacated.
Yeah, that person's no longer there because she's a felon. She was convicted of,
yes.
of several federal felonies.
I was trying to be footnote 36 nice.
Yeah. And look, I mean, the vindication I feel is immense because when the appeals court ruled on this, the Adnan team and their sort of media wing, their position was, this is no big deal, doesn't really matter, it'll just go back, we'll do it again, the exact same thing will happen. You could not, on the cesspool that is the Reddit True Crime Podcast subreddit, you could not even post about this because the mods would delete it because it didn't matter. It was completely irrelevant, right? And the whole time we were saying, you guys don't know what you're talking about. Because if you read the footnotes on the appeals court, they made very clear, like, no, this is substantively going to be different. The Supreme Court has taken the footnotes that were in that and incorporated them into their opinion with less venom, but with the same force. Now, the notion that this is going to have to be a real hearing where the evidence is tested, that is now part of the Supreme Court's opinion. And not only that, but they go further than the appeals court to allow young Lee to be the one who can advocate for that. And I'll tell you what else is interesting. It's interesting that it's going to be a new judge. It's interesting that it's going to be a new state's attorney. And in fact, the current state's attorney may recuse himself, which my hope is that eventually that will allow the Maryland AG's office to step in, who has been opposed to this release from the beginning. But what I think is interesting is there's the next step. So let's say this goes back and the same thing happens. It goes to the court says, look, whatever, state wants to let him out. I hear your arguments, young Lee, but I'm not going to get in the middle of this. He's released. I think under this opinion, something very important was created that we did not have before. Because young Lee now stands in the shoes of the adversarial process, I think young Lee can appeal the merits. I think he can appeal the merits to an appeals court and ultimately to the Maryland Supreme Court, where I think he's going to get a much fairer hearing than he is ever going to get in some local district court. So while I think most people still believe, and probably this is true, that the eventual outcome here will be that the conviction is vacated and Adnan Syed remains a murderer, but is no longer a convicted murderer. That may very well be what happens. But I think this now, the position he's in, is far worse than they ever could have imagined he would be in. In fact, they should never have appealed. Seeking cert when the Maryland Supreme Court turned out to be a huge mistake, because under the appeals court, I don't know if young Lee would have sought cert anyway, but assume he doesn't, or assume the Maryland Supreme Court doesn't take it from him. If it just goes back based on the appeals court decision, then, I mean, it's probably just going to happen again. But now the entire situation is different. The legal landscape is different. The position of Young Lee is so much stronger. And, I know he listens to the podcast because I watched his press conference, which very clearly was aimed at some of the things we said. If I'm Adnan Syed, I am looking for a deal because it's not a fait accompli anymore, and it's not a guarantee anymore, and there is a real world where he goes back to prison. I don't think that's what's going to happen, but it's a real possibility. And now that it's a real possibility, cutting some sort of deal, which I think the state of Maryland would be fine with at this point, where he remains a convicted murderer, but he doesn't go back to prison, is probably in his best interest.
Beautifully said. Absolutely. This is not a fait accompli anymore, and it shouldn't have been. I do think seeking cert was a big mistake. I think remember, we've always said the people who shout loudest are not necessarily right. And that's why we started this with vindication, because justice has won out in this opinion. And I don't know. I think that he will go back to prison, but that is because I am Miss Pollyanna, and I think justice will always come at the end of the day. And he served a lot of time. He has a great, he being Adnan Syed, he has a great approach to why he should basically be able to not have to go back to prison. He should seek a deal today. But I don't know that that's going to happen because there is so much riding on really a farce. But here's what I do know. There continues to be much too much attention, time, ink, breath spent on Adnan Syed. This is about Hae Min Lee and the Lee family. I am really glad that their rights were vindicated here. Let's end this here. Let's turn our attention to cases that could really benefit from the time and attention, and go read this opinion and then close the book. We've said this all along. And some of you who knew nothing about this case still, you write 1-star reviews and you're like, why did you spend so much time on a really easy case? I agree with you. Let us move on, because the true crime community, we have already shown, can do immense good. Let this be an example where the loudest are not right. So don't listen to the loudest. Don't click on it. Don't give it breath, because it has real life consequences. It almost led to deep, deep injustice here. If the Maryland Supreme Court came out the other way, a terrible miscarriage of justice. There's more to come in this case, but remember that. What you do, what you consume has affected, will continue to affect real victims' lives, real defendants' lives as well. Let us move on from this case. It's not that interesting, guys. There are a lot of good, interesting cases that we should turn to. And I say not interesting, not because I don't care about Hae Min Lee and the Lee family, but because I think that we have only had to fight this hard on a very straightforward case because of people who don't know what they're talking about, who don't know the law, and who just shout from the rooftops untruths. Let us stop that and turn our attention for good, for real legal arguments, real factual arguments, real victims, and real defendants who could use our attention.
And I just want to say, everybody deserves a brother like Young Lee. I mean, Young Lee, he has fought for his sister. He fought for her when venom and vitriol was being spat at him on social media from all sorts of people, just some of the worst things you could imagine. But he never stopped fighting for his sister. And I don't know where this is going to end up, but, Adnan Syed and his massive media campaign that he has behind him has repeatedly fooled various judges into ruling in his favor, only to be smacked down by the appeals courts. It's happened over and over and over again because he's guilty. And that's never going to change. The fact that he's guilty is never going to change. And it is heartening to me to see Young Lee continue to fight to ensure that no matter what, I mean, look, he's 17 when it happened. He spent 20 years in prison. There's a Maryland law about youthful offenders like this. Maybe you argue he's a completely different person. He should get an opportunity to live the rest of his life. Sure, fine. But always is the person who murdered Hae Min Lee. He never gets to leave that behind. That's always part of him. It should be something he has to carry no matter what. And to see Young Lee continue to fight for his sister is just, it's amazing. And he is a hero. And as Alice said, he is the person who should be getting all the positive attention in this case. He and his family, and the fact that they continue to fight for justice for their sister. And it's frankly sad to see so many people in the true crime realm who claim to care so much about victims who are willing to walk all over Heyman Lee's family, because they're victims too, and they're fighting for justice, and they deserve respect for that.
With that, I hope this is helpful for those of you who may not have had a chance to read the opinion or maybe got lost in some of the legal jargon. But like I said, I thought this was a very well written opinion, and I do think it's very accessible, even if you don't have a law degree. Well, we've posted it. We will post the opinion again. Go read it. And thank you guys for always having very respectful discussion about this. I know emotions can get heated about it, but we are talking about real people's lives. So thank you for continuing to have this dialogue with compassion and understanding. Brett, is there anything else you'd like to add before we sign off on this case?
I think that's all I've got to say. You know, justice was done again. But justice is always a temporary thing, so you got to keep fighting for it. There's going to be more fights in this case, and we'll just have to see how it ends up.
Absolutely. Thank you guys for, telling us what you want to hear about and for listening to this as well. As we always say, don't take our word for it. Go read the opinions and the firsthand resources for yourself. That makes you a better consumer of legal news, a better consumer of true crime news. And I think it makes our entire judicial system better and more compassionate and better explainers and reasoners with those that we come in contact with every day. So with all of that said, let us know what you think. You can email us at prosecutorspod@gmail.com. You can find us on Twitter, Instagram, TikTok, Facebook. We love hearing from you, and we really do read all of it. If you like what you hear, leave a 5-star review. You get to ask a question, any question, and we answer it. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
But apparently she doesn't want to admit it. So
Dang it! I hope I'm not sick. Don't say that. Don't jinx it. For those of you who are keeping track, we're on like virus 8 of back to school. Back to school should just be called back to viruses. We literally, I went to the doctor. We've been to the doctor every week with different kids. And they're like, this last time my doctor was like, it's just another virus, man. I was like, another? This is literally like number 6. He's like, I don't know what to tell you. You guys catch it all. Anyways, okay. No, I'm not sick. No, don't say that. Don't say that. I felt great until you said that. Now I feel sick. Darn it.